Hello, everyone. स्टार्ट करना है कभी बातें करनी now focus. This is one of the brightest of the driving every understand. During the educational experience itself. So we have organized this webinar so that we can expertise knowledge beforehand. Because most of the students are from first year, most of the students are from the second year. So we are looking forward that all of the students should join the Moot Court production. It's the national level. So this is the webinar. That is I hope you all are good. I hope you all have active interest in participation in this webinar. Let us begin. Okay, very good. Hello, namaste, and welcome to everyone. I am the Untitled Chapter, a student of Dayanand College of Law. On behalf of the Dayanand Education Society's Dayanand College of Law, the Moot Court Club of our college has organized the Moot Court Orientation Program. As this is one of the most, as I said, this is one of the most important subjects, practical subject of the learners of law. So we are going to pay a kind attention to all what is being taught and being experienced by others and selectively, so that we see our students taking active participation in the future. Okay. Now I request our principal, Dr. Mohammed to give welcome greetings to all our students.
Respected teachers, coordinator of the program, Manisar, resource person, Dr. Shetty sir, and my beloved students. I'm standing here to welcome each one of you to today's program of this Moot Court orientation. Every year, as you know, that Moot Court is constituting its club, and we are expecting good number of response from our students. But due to some language problems, or they are not aware that we have club and orientation classes are being delivered by these teachers, so that's why we have arranged this program. Many new and first year students are there, and many questions they may be having, BLLB and LLB students, whether they can participate in Moot Court, what is Moot Court. It is simply just like the court and court procedure, how the court etiquettes are being followed, how to prepare the case, what are the facts, what are issues, how to raise the issues, and how to present the arguments, oral arguments are being done. So what is the procedure, how it should be done? From the first year onwards, we try to inculcate these things to our students. So it is only the club which are directly teaching you the court process. When you are going and joining the court, you will learn. But how to examine the facts, how to make the issues, what reasons you need to give for having the judgment, and what prayer you are putting before the court. These all things you are getting these trainings through this subject. The Moot Court subject is also there as a practical, compulsory practical for you. But still, we feel that from first year onwards, you should learn and by having the participation in this club. Today, sir will teach you how to present in Moot Court, how the memorials are prepared, and every case, it is one research topic. Just like you need so many efforts. You need to learn various laws. When you are doing LLB, each and every law we cannot teach you. Hardly 28 to 30 subjects we are teaching. So, if apart from these subjects, any issue comes, how you need to do study, that will be taught in this orientation. So, I hope that you will be having the fruitful session. And I am inviting all the students to come and participate in Moot Court Club. Every second and fourth Saturday, last year, sir, I had taken some classes. So this year also, I hope that sir will continue and will invite the students. Thank you everyone.
Thank you, ma'am. Now, before beginning, I would like to ask you all whether you have seen the structure of code that is being made in our college. देखा है किसी ने और किसने देखा है? यहाँ पे लड़कियों हाथ ऊपर उठाओ यार, देखा है तो ठीक है। कोर्ट में गए हो आप सब? हाँ या ना? थर्ड ईयर के स्टूडेंट्स गए हैं, फर्स्ट और सेकेंड ईयर के स्टूडेंट्स को पूछ रही हूँ मैं, ठीक है। आप जब कोर्ट में जाते हो और जब कॉलेज में यहाँ पे स्ट्रक्चर देखते हो तो आपको ऐसा लगता होगा ना कि कल आने में कि हम भी प्रेजेंट करेंगे यहाँ पे आके। वो अलग बात है कि हमारे कॉलेज की जो यूनिफॉर्म है उसके अंदर ब्लैक कोट नहीं है, बट जब हम प्रेजेंट कर रहे होते हैं मुझको कॉम्पिटिशन्स में तो वहाँ पे वो फॉर्मल ड्रेस कंपल्सरी है। तो जब यहाँ पे थर्ड ईयर के स्टूडेंट्स कर रहे होते हैं तो कि अगर आप चाहते हो ना तो फील जरूर लेना कि हाउ इट फील्स इनसाइड द वर्ल्ड, बिकॉज वहाँ पे जजेस अलग हैं, वहाँ पे एडवोकेट्स अलग हैं, हम सिर्फ इंटर्न बोल के जाते हैं। तो यहाँ पे जब हम प्रेजेंट कर रहे होते हैं, जब सर सिखा रहे होते हैं, तब हम ही लॉयर्स होते हैं, हम ही एडवोकेट्स होते हैं, हम ही प्रेजेंट कर रहे होते हैं और हमें ही पता होता है कि क्या और चाहिए हमें कि जो इसे ज्यादा फ्रूटफुल बना सकता है। जैसे आपने बोला है कि रिसर्च चाहिए है, अगर आप कोई भी केस ले रहे हो उस केस का प्रेजेंटेशन करते वक्त कंप्लीट रिसर्च इस टॉपिक का करना रहता है कि what all are the acts. When I was in my first year, I used to think that Moot Court is for third year only, but it is not the thing. In second year also you can participate in the Moot Court competitions. It is not a compulsion that you have to participate in third year only. Because third year you will be having multiple things to do. You will be given various responsibilities. At that time, it is expected that you are having an internal knowledge, a complete knowledge of that subject. अगर आप थर्ड ईयर में आके ये सोच रहे हो कि नहीं अभी हमें ये सीखना है, अभी हमें बनाना है और हमारे जिन दोस्तों ने ये प्रेजेंट कर दिया ये बनाना है बना दिया क्योंकि हम फाइल ले रहे हैं देख रहे हैं, तो दिस इज नॉट डन। क्योंकि आप जब वापस बाहर जाओगे तो फिर बैक टू नॉर्मल फ्रॉम व्हेन यू हैव टू स्टार्ट कि कैसे बनाना है, क्योंकि बहुत सारे सब्जेक्ट हैं जो थर्ड ईयर में है, फर्स्ट ईयर में नहीं है, सेकेंड ईयर में नहीं है, थर्ड ईयर में है, तो वो सब्जेक्ट एलिमिनेट कर दो, पर बेसिक सब्जेक्ट जो फर्स्ट और सेकेंड ईयर में है उसको लेके यू स्टार्ट एंड यू विल बी एबल टू प्रेजेंट वेल इन योर सेकेंड ईयर itself by reading the various case laws. Not taking much time, I will request our resource person, Professor Shetty sir, to give us an introduction and a complete outline of the entire Moot Court competition and how we have to understand to present in the Moot Court competitions.
Thank you, Priyanka. Respected Principal Madam. Respected Principal Madam, my esteemed colleagues and my dear students, online as well as offline. Very good morning to you all and a warm welcome to all as well. We have a full house here. I hope I will give you something today which will enrich your knowledge as far as your law profession is concerned. So today we have Moot Court and mooting. Now this is an orientation program. Orientation means the background of that Moot Court so that you can understand what actually is meant by Moot Court. It is an essential part of your curriculum. So we have Moot Court as a practical subject in the third year of LLB and as well as final year of ESM. It is a compulsory subject. The problem is, till you reach the final year, you don't know what is Moot Court is about. Now this is an effort where you will be given the basic knowledge of Moot Court so that when you reach the final year, you know exactly what you are supposed to do. So this is the program as orientation to give the brief understanding background how a Moot Court is conducted. The object of every institution, especially the professional institutions, is a holistic development of every student. Just imparting the provisions of the law is not sufficient. Even if you have the 100% knowledge of each and every law of the land, that is not sufficient. Applicability is important. To be able to express yourself so that whatever you have learned in the college, you have to be able to apply those laws. Then only you can be considered as successful in that profession. Let me give you an example of the profession of medical profession where doctors, they study theoretically as well as they have ample amount of practice. Suppose the medical student is given theoretical knowledge of diagnosis of a disease and you send him to a patient, go and diagnose the disease. Will he be able to do? No, because he does not have practice. Secondly, in critical conditions, some of the patients need operation. Can a student who has theoretically learned everything, you have procedures as well, if he is asked to go and operate a patient, will he be able to do that? No, again. Why? Because he does not have practical knowledge. In the same way, lawyers, you have ample amount of knowledge as far as provisions of each and every law is concerned. But applicability, you have to learn through these practical procedures. That is what we are going to do in Moot Court. The applicability of before various courts, especially when you say Moot Court, we mean to say that when the procedure followed by higher judiciary. When we say higher judiciary, it means High Court and Supreme Court. As far as the lower court is concerned, the practice which is followed as far as training is concerned, that is called as mock trial. So the difference between mock trial and Moot Court. Mock trial is conducted in the lower courts, the practice which is followed in the lower courts, where witnesses depose before the court. Examination of witnesses is conducted before the court, that we are not following here. We are teaching the procedure which is followed in higher courts, High Court and Supreme Court. While we are into Moot Court, what we do is we simply enact as if we are in the real court. The real court में जैसा procedure चलता, we are following that. Enacting whatever procedure is followed in the High Court and Supreme Court, we are doing in an imaginary court. This is not a real court. Whatever infrastructure we have in the college, this is not a real court. It is imaginary court. So to develop a person as a holistic development, it is the Moot Court is a part of that. I strongly believe that when a student comes to any educational institution, he is a raw material. Take example of a potter, the person who makes a pot. He is being given a raw material, a clay, lump of clay, and he puts it on a wheel. and revolves it, and he packs the lump of the clay, and he gives it a proper shape. When that lump of clay gets a proper shape, then only it has some kind of value. Otherwise, it has no value. What I believe, every student who takes admission in the college tries to pack the students so that they can be molded into a professional. This is what we do in the college, and this is one of the efforts. Moot Court is one of the efforts where the holistic development of a particular student is done through this Moot Court. So this is as per the background of the Moot Court. Now we will see what is the actual meaning of Moot Court. A Moot Court is a simulation on real court of law to give students an insight on dealing with a legal problem and how to present a case before a court of law. This is a simulation. Simulation means we are doing exactly, we are enacting exactly how a procedure is done before the courts, High Court and Supreme Court. We are keeping aside the trial courts because we are not conducting mock trials. Proceedings in the courtroom follow a set of pattern of conduct, right from the attire to the language. So when we say the proceedings, it has some certain set of patterns, right from the attire. Attire means the clothing. The clothing we are supposed, the uniform we are supposed to be wearing in the courtroom as well as in Moot Court competitions. Apart from that, the language, the kind of language we use in this court, in the real courts as well as the Moot Courts, we cannot use the layman's language. The language we use in our normal conversation, that cannot be used in the courts. There is a set of pattern. The language, the kind of language, the mannerisms which you are supposed to observe in the courtrooms, that we are going to learn here. The way we behave, the way we conduct ourselves, there are some certain norms which are covered in this presentation. Moot courts give law students a chance to get as close as to the real life lawyering. When I said this is not the real court, but it acts as the real court. This is as far as close you can go to the real courts. So unless you practice this in the Moot Court, supposing some certain years back, this Moot Court was not as a subject in your curriculum, around 20 years back or so. Now it has been introduced as a practical subject so that you have first-hand learning of the procedure which is followed by the courts. Essential part of it, which you can learn. Now, what is the purpose behind that? You learn real life skills and practice them every day as a preparation for life as an advocate. Why it is needed? As I explained earlier, in the profession of a doctor, how students learn unless they participate in operations along with their senior doctors, they will not learn how an operation is conducted. But here there is no senior doctors, senior lawyers, so it's going to spoon feed you. You have to learn these things through Moot Courts only participation. Once in a while, if you participate, you will not be well conversant with this practice. You have to practice this regularly. So that is where we have Moot Court Club, which regularly conducts class, where every student, certain students may have their oratory skills as a verbal skill, but many of us have to develop this skill, oratory skill. Having knowledge is not enough. You should be able to express it. You may be a taekwondo, you may be a gold medalist in the university. All the religions are by to you, but if you are not able to express it to the audience, having that kind of knowledge has no value. This is the first step we begin. We make every student to participate in seminar presentation, debate, involve them in debating, so that you develop your oratory skills, your argument skills. This is the first step in the Moot Court. When you develop this skill, then the next thing we do is we take up a problem. When you say problem, it could be a decided case by the High Court or the Supreme Court, or maybe an imaginary case. The first thing we have to do is we should be able to segregate what are the facts of the case. The head notes are available in reporters. Reports of Supreme Court cases, report of High Court cases are available in reporters as a head note. When we say head note, the brief description or the summary of that particular case, the facts, issues, and the decision by the court. It is not given in detail. As a head note, it is available. So when you go through the head note, what you must do is you should be able to segregate the facts of the case, the issue of that case, and the decision given by the courts. And the reason behind those decisions, which is called as ratio decidendi. Ratio decidendi means the reason for that particular judgment, why that court has arrived on that decision, the reasons behind that. This you should learn to segregate from a given problem. That is the second step you learn. After going through that, you should be able to write up a brief memorial. Memorial means a written submission to the court about the facts, issues, what is going to be your submission before the court, and what is going to be your prayer. Prayer is, it does not mean you're praying to the God. You're praying to the court. What remedy you're seeking from the court. Now, you are a separate party here, you are an aggrieved party here, you are seeking something from the court. You are before the court because you want something from the court. So that is called as prayer. What remedy you are seeking from the court, that is called as a remedy. That is called as prayer, through which you seek the remedy from the court. These are the three steps in a Moot Court presentation. As I said before, Moot Court means simulation of the higher judiciary. Simulation means you are enacting how a procedure goes in that court. Moot Court means simulation of higher judiciary. When you say higher judiciary, it is High Court and Supreme Court. When you say mock trial, it is a simulation of trial courts. You know the difference between these two? Trial courts. Trial courts are the lower courts. Lower courts where facts are proved. Facts are proved through deposition of witness, leading of evidences. A witness to that particular incident is brought before the court and he deposes before the court. Examination of witnesses. On the basis of that witnesses, the law is applied to the facts of the case and the court arrives at a decision. Now supposing the lower court commits a mistaken application of law, then what is the remedy available to you? You can make an appeal to the higher court, that is High Court and Supreme Court. That is the normal procedure. And every court has its original jurisdiction also. We will not discuss about that now. So let's see the attire. Attire means your dress code. What dress you are supposed to wear when you are representing your college as a Moot Court contender. Before I proceed, what we do in Moot Court is we prepare teams. Once your training is complete, we prepare teams so that they can participate in competitions. Various colleges arrange Moot Court competitions, inter-collegiate Moot Court competitions. We prepare teams through our Moot Court club. So, when you compete or you represent your college in Moot Court competition, you have to follow this attire. In order to argue for the case in the courtroom, one needs to don a specified court uniform. A standard court uniform includes a black suit with a black tie or white band. You can wear black suit is important. White shirt on that black jacket. Either you can wear a black tie or a white band. No unnecessary accessories. No ID. When you are competing in the Moot Court competition, you should not carry any ID which exhibits your identity to the judges. Now, suppose you are representing the College of Law, you should not carry any ID which exhibits that you are the student of the College of Law. What is the purpose of that? There should not be any biasness as far as how much mark you get in your presentation, Moot Court competition. There should not be any limiting activity as far as your college and university. Then you will see court etiquettes, your mannerisms, how you behave before a court. In imaginary court as well as the real courts. Go before the judge as soon as you enter, regardless of his attention or presence. Even if the judge is not present on his dais, you should go before the chair when you enter the court. Even if the judge is present in his chair, but he is not looking at you. Don't think that the judge is not looking at me. I will enter the court according to my wish and will. Don't do that. Know yourself. Pay respect to the judge, even if he is not looking at you. The appellant has to take the left sitting, and the respondent has to take the right. This is the procedure followed by the students participating in the Moot Court competition. If you are representing appellant side, you have to take the left side seat. A respondent will take the right side facing the judge, unless contrary is arranged. This is the normal procedure. If the organizers of the Moot Court competitions have any something else, then you behave accordingly. Or the sitting arrangement, if the sitting arrangement is made contrary to this what I have specified, you have to follow that procedure. Otherwise, left seat is made available for the appellant, the right is for the respondent. If the judge enters the courtroom, stand up. When the judge reaches his chair, go before him and take your seat only when the judge is seated. This you must compulsorily follow. When the judge indicates, then the first counsel must approach the podium and go before the judge or the bench. It could be a single judge bench, it could be a two-judge bench, or it could be a divisional bench or a constitutional bench. Single judge means on the dais there will be one single judge presiding over. Two judge means two judges. If it is a divisional bench, it is 2 to 4 judges. And if it is a constitutional bench, more than 5 judges. When the judge indicates, then the first counsel must approach the podium and go before the judge before starting the arguments. So this is the standard procedure. Don't just go and start blah 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 blah. You have to go before the judge. You have to seek permission from the judge. May proceed. Then only you can start in your submissions or the arguments. Single main judge on the bench in the Court of Appeal is to be referred as my lord or your lordship or your honor. Now these are the salutations which were being used since Britishers. When they were ruled by Britishers, using their rule, we had courts in their system, and these salutations were used by the Britishers. My lord, your lordship. These have been done away with. Supreme Court has urged the advocates that you don't have to use these salutations. If you simply refer as your honor, and sometimes if you even refer as sir, is enough. So use these words. You can use my lord as well, because this has been the procedure being followed since very long. Then, a lady judge is to be referred to as your lordship. Don't say dear. Never. Introduce yourself as counsel for the side, represented by you. How you introduce? Don't introduce yourself by your name. You must say, I am the counsel for the appellant or the petitioner, or I am the counsel for the respondent. If you have been given a particular ID number of your competition, you can mention that, your ID number. Otherwise, don't disclose your identity. Mention the contentions, issues, submissions to be taken up by you. If the arguments are divided, then also mention the contentions taken up by co-counsel. Now, what is with the co-counsel? When there is a competition, you are allowed to be represented by 2 students as speakers. Team consists of 3 students, 2 are speakers, 1 is a research person. Only 2 people are allowed to speak in the competition. So you may divide the issues. If suppose there are 4 issues or 5 issues, you may divide these issues amongst yourself, amongst the 2 speakers. And you must mention beforehand to the judges that I will be submitting the first 3 issues and the rest of the issues will be submitted by my co-counsel. Then there are some do's and don'ts. When judge is consulting among themselves, then a counsel should never interrupt. There's a possibility that when you're during your submission, if it is a 2 judges bench or a divisional bench or a constitutional bench, there's a possibility that during your submission, the judges might feel that they should discuss on a particular issue amongst themselves, and the discussion is going on. Don't interrupt the judge. Don't proceed in your submissions unless they stop you and they give you permission to proceed with. Never interrupt the judge when he's asking or clarifying a point. Now you are making a submission before the judge. You want some certain clarifications. Please maintain silence. We are in a noble profession. Keep that decorum in the class. Never interrupt a judge when he is asking or clarifying a point. During your submission, the judges may want a clarification. He is asking a question. Don't interrupt him. Judge, let him complete the question. There is a possibility that when he starts, you have understood what he is going to ask. लगेज तुम्हें answer start करो ना. Don't interrupt him unless the judge completes his question. Never point a finger or behave arrogantly or be hostile towards the opposite party. See, during your oral submission, if you have a control over your hand movements, if it is a positive thing to do, then use that. But don't overdo it. So have complete control by your hand movements. Don't point a finger at the judge. Don't overdo it. Positive effect होता है तो थोड़ा बात करो शकता तुम्हें, but otherwise don't overdo it. You should have complete control over your hand movement if it has a positive impact on your submission. First तुम्हें hand movement ही वापर करा, otherwise no. Do not start with the rebuttal by seeking an answer from the opposite party, opposite team. Instead, wait for the time reserved for rebuttal. if there is any such provision is made. So, after completion of your submission, the opposite party is given to make their submission. Don't interrupt him. It's at any point, if you want to rebut, if you want to contradict him, don't stop him. You will be given separate timing for that. Supposing the point which is being submitted by the opposite party is not acceptable to you, don't stop him immediately. Rebuttal देना करूँगा. Rebuttal साठी वेगळा वेळ दिला जातो. Separate timing is given to you for rebuttal. So these are the standard procedure which are being followed. Avoid saying thank you. This is a normal conversation मध्ये. Thank you म्हणतो. Don't use that word. Thank you. Instead, you use highly obliged, Your Honor. If judges give you some advice, or maybe on a legal point, you correct it. If the judges correct you, at that time, naturally you are obliged because being a highly qualified person, he is giving you some advice. You are learning something out of it. So don't say thank you. Say highly obliged, Your Honor. Seek permission of the judge or the judges to proceed further. Whenever the judge stops you for any clarifications, then after giving the clarification, don't proceed with your submission. Seek permission. Your Honor, may I proceed with the submission? When you are given the permission, then proceed with your submission. Never say, may I carry on. Don't use this salutation. Avoid using slangs such as yeah, okay, all right. This is the words, the phrases which we use in our normal conversation. Such salutations, such words cannot be used in a court of law. Why? We have to maintain the decorum of the court. So we all know we have 4 organs in a democracy, pillars of a democracy: legislative, executive, judiciary, and the 4th body is the media, the new introduction to the organs of a democracy. Now, if you ask any person, which organ commands most of the respect of anybody, it is the judiciary. Faith, the faith of the people. They may not have faith in the legislature, they may not have faith on the executive, they may not have faith on the media, but certainly to a great extent they have faith in the judiciary because the judiciary commands respect. How this command is being done? It is because of the kind of language, the ethics, the code of conduct being observed in this judiciary. So that is why you should not use this kind of language as a layman. Now, what are the preferable salutations? May it please your lordship, Your Honor, with your due permission of your lordship, the council seeks permission. These are the acceptable salutations. This is how you are supposed to address the court or seek permission. May it please your lordship, Your Honor, with the due permission of your lordship, the council seeks permission. This kind of salutation is acceptable in the court of law or in the Moot Court competitions. And most importantly, never display your back to the bench. When you say bench, it is the judges or the court. Then calling the co-counsel. I have already explained what is the co-counsel. A particular side, maybe petitioner or the appellant, may be represented by 2 students. So those 2 students, one of them is called as co-counsel. When the first counsel finishes his argument, then he should ask permission to call his co-counsel to further carry the argument. The priest which is advised to call upon the counsel is the counsel humbly seeks permission to call upon the co-counsel who will be dealing with or continuing with the submissions. This is how you call upon your co-counsel. Second participants, second speaker I, how he is called to make the submissions. The counsel humbly seeks permission. The first counsel who has been making submission, he has to use this salutation. The counsel humbly seeks permission to call upon the co-counsel. Are you following? Yes. Okay. When permission granted, then go before the bench and take your seat. Do so without showing your back. When the permission is granted, the first speaker must sit down without showing his back, and the second counsel, co-counsel, should be allowed to speak or make his submission. Then tips for the researcher. I have already explained that the team consists of 3 members, 2 speakers and 1 researcher. All the above tips are applicable mainly to oralist. Whatever discussion we have made till now, it refers to the speakers, not to the researchers. Now, what are the tips for the researchers? All the above tips are applicable mainly to the oralist, but research should also observe the same court manners. Researcher is not a speaker. Active role in he does not have active role. Whatever I am discussing is for your own good. If you don't learn things, you are going to face difficulties when you pass out of the college. This is important for your practicals. So don't disturb the class. See, sometimes what happens is the oralist, the speaker, they need information from time to time when they make their submissions. At some point, they might get stuck down. Immediately you have to, but what is the work of the researcher? Whatever information is required by the speaker has to be provided by the researcher. See, all the researchers have been completed in a coordinated manner. Clearly, research conduct and researcher also has the knowledge of that particular case. Immediately, whenever the speaker wants some information, maybe he need to present the citation. Now, what is meant by citation? Under Article 141 of the Constitution, every judgment, every pronouncement made by the Supreme Court of India will act as the law of the land. That has to be followed by the lower courts. It becomes a law. And suppose you want to make a submission to the court before which you are presenting your case. The facts are similar. Facts of the decided case and the case which is before the court now. Facts are similar. At that time, as per the provisions of Article 141, the judgment, the rule which is made by the Supreme Court will be applicable in this case also. So if there are any citations, the case law which is decided by the Supreme Court, which is in support of your submission, that you have to submit that citation before the court. Now researcher has to help that. In that, researcher will hand over the citation to you so that you can present that before the court in support of your claims or the submissions. That is why the researcher helps you in a moot court competition. Then leaving the court, how you are supposed to leave the court, and the judge leaves his chair, get up and go before him. You should not sit down. When the judge gets up from his chair and is ready to leave the court, then all of you must present in the courtroom. or in a moot court hall, you must stand up. Wait for the judge to do before proceeding out of the court. Unless the judge leaves the courtroom, you should not leave. This is the standard procedure to be followed. Now, these are the basic things as far as moot court presentation is concerned. Now, we'll look into the preparation, how you prepare for the moot court competition. First thing you have to do is pick up the moot court problem. Picking up a moot court problem means the case which you are going to find in your imaginary courts. It could be a decided case which is decided by the High Court or the Supreme Court, or it could be an imaginary case. This is the first step of preparation. Many times in moot court competitions, the organizers of the moot court, they provide you the problem or the case. Rules and regulations are specified, and sometimes issues are also provided. Along with the problem, along with the case, sometimes issues are also provided by the organizers. In that case, in addition to those issues, if you feel that there are some issues which has to be highlighted, then you can add those issues in your presentation. Rules with regard to the represent both sides or one of the sides, rules of time limit or oral presentation, number of maximum words and font spacing in memorials, deadline, etc. All these rules are given in the moot court organizers' rules and regulations about the time which is available for oral presentation and the number of pages in the memorial, and the spacing of the words, the size of the font, each and everything is specified or mentioned in the moot court problems, along with the moot court problems as rules and regulations. See, time for presentation, oral presentation is very important. तुमच्याकडे पूर्ण दिवस नाहीये. अर्धा तास एक तास you are not allowed to. Maximum 15 to 20 minutes are given. Within that specified time, you have to present your oral presentation. They keep your watch on how much you take, how much time you take. Once you fix that time, at the time allowed to you, they will ring a bell. So, if you are not finished with your submission, so that you make a point before the judges, then you will not go to the next stage. So, what is important? By observing the time limit, you should be able to present your case in full. Whatever you want to specify, within those time limit you have to specify. So, consumption of time limit, this is very essential. But unless you practice this beforehand, you will not be able to present within the time limit. So keep this in mind. Then sometimes option of choosing the problem. When choosing the problem, care should be taken. Choose a well-balanced problem, allowing both the sides to argue their case. Now suppose the problem is not given by the organizers, you haven't given the option. You choose your problem and accordingly frame the issues and make the submissions. In such cases, while you choose the problem, you choose such a problem so that equal opportunity is given to both the sides. As you all know, there are two sides to a case, so equal opportunity should be given to both the sides. Next stage is research, very important stage, which students avoid. This is a difficult part, and students usually want to avoid this. But unless you do this research, you will not be able to succeed in the competition, or for that matter, in your real life also. When a client approaches you, if you want to represent that client, you have to conduct research if you want to succeed, and if your client wants to succeed. Research is very important. Research means you have to thoroughly study the facts of the case. Is काय facts are, what are the issues, And in addition to that, as I said before, citation is very important part of any submission in real court as well. Actually, the lower courts don't decide on them. Mainly they decide the case on the citation you provide in your paper. So this can be done only through research. Research means you read the problem, don't depend on the headnotes which is provided by the reporters. They report in the book. Detailed sometimes the decision of the court runs into thousands of pages. It is not possible to give all the details in headnotes. Headnotes means it is a summary of a particular case. Reading headnotes is not enough. Through headnotes, you get only summary. Go through the case, which is available online. Read in detail. Read again, so that you come to know the actual facts and the legal points concerning that case. This is very important. Don't think that one or two readings will give you all the information on that particular case. Read again. Until you understand each of the facts, each of the issues, the decision made by the court, and the reason behind this decision. Then only you will get to know this is part of research. Pick up the relevant significant facts of the case, while insignificant facts may be ignored. See, it is not possible to mention every fact of a case. Pick up some significant facts, on the basis of which the decision might change. Such facts you must choose and leave out the insignificant facts. The insignificant fact, if you even leave out that, because that much we cannot disclose in your memorial. But if it is a significant fact, don't leave it out. And what is important is read the full judgment. Full judgment what's up? Summary judgment. If you read the summary judgment, the reason behind that judgment will not be, you will not be able to understand the reason behind that judgment unless you read the full judgment, which is very important. As a practicing lawyer or as a student participating in the Moot Court competition. Then search for previous judgments of the Supreme Court on similar facts and quote them as citation. This is very important step. If you want to win the case for your client, you have to find out the citation. Citations means the judgment which is given by the Supreme Court. Then while you search for this citation, also look for whether the earlier judgments are overruled by the higher bench. Are you able to follow this? While you are looking for a citation, if there is an overruling, so till now, suppose you have been following a particular citation on a particular matter. Now, a new case has come before the Supreme Court, and the earlier judgment was overruled by the higher bench of the Supreme Court. What will prevail? Which decision will prevail? The latest judgment. So it is very essential that we look into the latest judgment on a particular legal point while you cite or give a citation to the particular case. A wrong citation may go against you. चुकीचे citation दिला without reading the whole case, that the decision might go against you. You might be thinking the decision is likely to come in my favor, but if you give the wrong citation, the decision will go against you. That is why do the complete research what this citation is about. It is important to know the facts of the judgment of the cited case. Case cite karta, you should know the facts of judgment of that particular case. Unless you do that, unless you study the entire thing, don't cite that. Because there is very likelihood that the decision may go against you. This is the part of research. Study the High Court judgment of the cited Supreme Court judgment so that you know why an appeal is prepared. So this is not enough if you study the judgment of the Supreme Court which you are putting before the court. जो case cite करता means court की समझ. You go through the judgment of that particular case by the Supreme Court is not enough. You have to go through the case. Why that case has been appealed against when the judgment is given by the High Court. High Court becomes Supreme Court of delay. Which is pretty much a reason also you should know why you cite a case. Sometimes you may have to refer to the foreign cases and academics also. When there are no judgments available on a particular matter, you may have to refer to the foreign cases for the judgment also. And the academics. Academics means the writings of eminent jurists. Example I in Citation versus Union of India, Justice R.F. Nariman considered the jurisprudence for the rest of the world. It's about Section 66A of the Information and Technology Act, which provides for maximum 3 years of punishment and fine for sending an offensive messages to electronic and internet media, which was misused by the police. This section has been misused by the police but several times. When even an innocent message through electronic media, people have been prosecuted. This is one such incident. Sriya Singhal versus Union of India. A particular law student questioned the authority behind closing down of a particular city after the death of a particular politician. This message was sent through the electronic media and she was arrested and charges were framed on Section 66A of the Information and Technology Act. When a petition was filed before the Supreme Court saying that this is against the Constitution, against your fundamental rights of speech and expression, which is guaranteed under 19.1. Article 19.1 मध्ये तुम्हाला right to speech and expression has been given as a fundamental right. Now, you have a provision in a particular law which infringes this fundamental right of speech and expression, where you cannot express. Authorities have been misusing this power. Even a particular innocent message sometimes is considered as offensive message. So what is the provision under this Act, Information and Technology Act, under Article 66A? You cannot send any offensive message through electronic media, mobile असू द्या, internet कुठल्याही याच्यामध्ये. You cannot send a message which might cause disharmony. There could be chaos in the society. As a message तुम्ही पाठवू शकत नाहीये. If you send such messages, you will be punished according to the provisions of that law. Now, this was challenged before the Supreme Court as unconstitutional. 66A, Section 66A of the Information and Technology Act. It was challenged before the Supreme Court, and since there was no material available, Justice Nariman took up jurisprudence from the world. बाकी देशाची jurisprudence आहे law. त्याच्यात material घेतले. And he decided that this provision is unconstitutional, which takes away your fundamental right of speech and expression. It was struck down as unconstitutional. So what is the purpose of mentioning this case is that even if the material in support of your claim is not available in Indian law, you can take up certain decided cases or the material from the eminent jurists from the world over. देशाची बाहेरून पण तुम्ही घेऊ शकता, and you can cite in supporting of your claim. So, under this, petition was filed under Article 32 of the Constitution for violation of speech and expression. And the court struck down this as unconstitutional. Another important step is drafting of a memorial. When we say memorial, it means it is a submission made in writing. The supporter of submission karto. The oral submission is a different thing, and written submission is a different thing. We cannot make every submission in oral submission. So in written submission, detailed submission is made. So whatever submission we make in writing, that is called as memorial, Moot Court memorial. As far as competition is concerned, you win the half of the battle is won when you drafted a good memorial. Memorial sound less better, at least you can consider it as you have won the half of the competition. So there is special prize for Moot Court memorial also, apart from the first team, second team, best voter and best Moot Court memorial. A surprise dinner at the Moot Court competition. Best memorial wins you half the battle, and that is why we need to give ample time towards precise drafting. So this will not happen in one drafting. In draft, but a complete memorial you cannot finish. You draft it, reread it, make the corrections, add something to it. Whichever just the efforts लागतो when you make the memorial. Address all the issues in the memorial, even though which support the opposition. See, complete drafting is very essential in the real courts also. When you make a plaint or when you write a petition, whatever you want from the court, you have to submit all that in one submission, written submission. You are not allowed to do that again and again. तुम्हाला असं वाटतं की आज मी रायटिंग मध्ये कंप्लीट केलेलं नाही. You remember something else. आज complete submission complete केल्यानंतर you remember something else. I have forgotten to add this. Can you take it back from the book? I will add this and again submit. This is not allowed to you. So in the same way, memorial, whenever you are preparing a memorial, think of it, read again, and whatever things which you have missed out, you want to add in that memorial, you do it before you complete and present it to the public organizers. So let's see the contents of the memorial. Memorial मध्ये काय असायला पाहिजे? The content of memorial is divided into various heads, which are as follows. First, cover page. Second, table of contents, that is index. Every page मध्ये काय आहे. Then index of authorities. I will explain it in detail what are these things. Statement of jurisdiction, statement of facts, statement of issues. Summary of arguments, arguments advance and prayer. These are the contents of a memorial. Let's see the detailed contents. First thing is cover page. Cover page मध्ये काय असायला पाहिजे? Name of the Moot Court competition. Who is conducting the Moot Court competition? Now, name of the court before the petition appeal is being filed. Which court? Whether it is a high court, if it is a high court of which state, if it is a Supreme Court, then mention that it is a Supreme Court. Name of the matter, that is the parties, petitioner versus respondent. Dispute so but who are the two parties that you have to mention in the cover page. Then, at the end of the first page, cover page, most respectfully submitted on behalf of. You are submitting the Moot Court memorial either on behalf of the petitioner or on the respondent or the appellant or the respondent. So you mention that on whose behalf you are submitting this memorial. table of contents, disclose subject heading and page number of each subject. कुठला page मध्ये काय आहे? That is table of contents. Then index of authorities. Authorities means, so whenever you make a submission, it has to be done by certain statutes or Constitution of India. Statutes means वेगवेगळे कायदा आहे, enactment आहे. If you are specifying certain sections which are applicable to that particular case, then mention. Suppose if you are specifying certain sections from the Indian Penal Code, then write Indian Penal Code. Treaties and conventions. International treaties and conventions may also be applicable to a particular case. Then, if you are taking some provisions out of international conventions and treaties, you also mention that. Suppose, for example, Universal Declaration of Human Rights 1948, which are provision for the submission, you mentioned that Universal Declaration of Human Rights 1948. Then judicial decisions. Judicial decisions means the decisions made by the High Court and Supreme Court, which you are citing. Then books and essays, articles and journals. I have told you earlier also, sometimes we may have to follow the research made by eminent jurists. This also we might have to cite in our submissions. In that case, which book you have followed? The writings of the eminent jurists, कोणाची follow केलेलं आहे, तुमचे नाव आणि book. That also we cite. Then index of abbreviation. Disclose all words which are used in short form. For example, AIR, All India Reporter, SC, Supreme Court, SCC, Supreme Court Cases, SCR, Supreme Court Reporter, PIN, Public Interest Litigation. We may be using these cases in short form. So you devote one page for this index of abbreviations. Statement of jurisdiction. This is the essential part of a Moot Court memorial. When you go before the court, the court must have the jurisdiction to try that case. प्रत्येक कोर्टाची वेगवेगळे jurisdiction आहे, authority आहे. Each and every case cannot be brought before every court. प्रत्येकाची jurisdiction आहे. You are supposed to take that case before that particular specified court only. This is called the jurisdiction of that particular case. Now, when you take a particular case before a High Court or a Supreme Court, under which provision you are bringing that case before that particular case, that has to be mentioned as jurisdiction of that court. And that is called a statement of jurisdiction. Example, Article 32. Now, suppose your fundamental right is violated. You want a writ order from the court that you can approach through Article 32 for enforcement of your fundamental right through writ jurisdiction of that particular court. Court will issue a writ after hearing you if it finds appropriate to issue a writ order. Article 131 Article 132 Article 131 is the original jurisdiction of the Supreme Court. 132 civil appeal, 133 civil appeal. Article 134 the criminal appeal. Article 136 is special leave petition. If the High Court does not give you a certificate that if this case is fit for appeal to the Supreme Court, in such cases, you can approach the Supreme Court through a special leave petition under Article 136. So, in such cases, you have to mention how this court has jurisdiction to try this case. That is very important. Article 226, which applies to High Court. If your fundamental rights as well as other legal rights are infringed, then for a writ order, you can approach the High Court. So whenever you approach a particular court, the provision under which you are approaching that particular court, you have to specify that in the memorandum. Statement of facts. Statement of facts. State all the important relevant facts relating to the case. No need to state all the facts. Important facts, which matters, material facts. Material facts means the facts you cannot miss out. If you miss out on that fact, the ultimate result may not be in your favor if you miss out any material facts. So include all the material facts. Some not so important facts you can leave it out. After that, statement of issues, this is very important. You must understand what is meant by statement of issues. Issues means the legal point on which you need the opinion of the court while you have approached that particular court. Now, if you are an agreed party, when the lower court decides the case, you say that the application of a particular law is not properly made. Then you should point out that this particular law has not been applied properly. We want your opinion as a higher judiciary whether this particular law has been applied properly or not, whether a particular matter has been properly interpreted by the court or not. ये तुम्हें decide करा, as a court somehow we are seeking remedy on this issue, then it is called as an issue. So you should be able to understand the difference between facts and issues. Facts म्हणजे जे काही घडलेलं आहे, those are facts. But issue means you are approaching a particular platform, particular court, maybe it is High Court or a Supreme Court, asking the court, we want your opinion on this particular point. Then that is called as an issue. So you should be able to segregate between a fact and an issue. Then summary of arguments. Detailed contents of what arguments you are going to make in your client's favor. If you want to win a case, you have to make submissions on behalf of the positive points on behalf of your client. Even if there are certain negative points, you are not supposed to mention that. Positive points in your client's favor that you make an argument or make the submission. This is called as all the arguments in favor of your client in short. Argument advanced. Speak in detail the arguments to be made in support of your claim before the honorable court. And the last thing is prayer. As I said before, it is not prayer to the God. It is the prayer to the court. Say what you need from the court. What remedy you are seeking from the court. That is called as prayer. So how you can frame this prayer? In the lights of the issues raised, arguments advanced, and the authorities cited, it is humbly requested that this honorable court may please do. This should be the statement. What you are writing that? Issue, in the light of issues raised, whatever issues we have raised, and whatever submissions we have made, and authorities cited. Authorities means the supporting, the citations, the writing of the jurist. We have brought that the provisions before you. On the basis of that, you give us a judgment. This is the prayer which is made before the court. See, as far as oral submission is concerned, as I said before, there are normally 3 members in a team, out of which 2 are speakers and the other one is researcher. So if you don't maintain the silence in the class, so कोणासाठी आहे मला सांगा. Am I wasting my time? Running order of a moot court. There are normally 3 members in a team, out of which 2 are speakers and the other one is a researcher. The team composition is 2 speakers and 1 researcher. Once a judge is seated, everyone takes the seat and the argument commences. The lead speaker of appellant petitioner approaches the podium and makes his submission. The person who is making the appeal or the petition is given the first chance to make his submissions because he has come before the court with that petition or the appeal. So he is being given the first choice of priority to speak before the court. Starting with the submission of the jurisdiction of the court and proceeds with the submission on various issues. Also, he answers the questions posed by the judges. Every section of any act which was specified or any provision was specified, simply mentioning of that section or provision is not sufficient. You are supposed to know what that section provides for, what that provision is about in detail. So there every possibility that when you make the submission saying that section 45 under IPC or article 144 of the article, the judge may ask you a question what this section is about. Then you should be able to answer that. Simply mentioning of that particular section or the provision under the article is not enough. You should know that thoroughly. It is also necessary to know the provisions of all the sections and articles specified in the submission. Upon completion, he seeks permission of the bench to call the second speaker to make his submission. When the submission is complete, speakers for the respondent are given a chance to make their submission. As a concluding part of the submission, counsel for appellant petitions are given a chance for rebuttal. It is important. Rebuttal. तो व्यक्ति submission झाल्यानंतर after the submission of both the parties, if either of the party wants to make a rebuttal is contradictory statement, the chance is being given to him. You cannot go on and on. Or समजा petitioner एक submission केला, then you make a rebuttal. This is the contradictory claim. Again, that party makes the submission. Again, you make a rebuttal. This is not allowed. Particular time दिला जातो. त्याच्यामध्ये every rebuttal, whatever you want to make, you have to make that rebuttal in that specified given time. And after this submission, after the rebuttal, your evaluation is made by the judges. How was your performance? As far as Moot Court competition is concerned, as far as the real court is concerned, everything depends on you. Your career is different. Your career depends on that. How you represented your client. Now, if you are able to win a case for a client, one more client will come to you, and he will give his case to represent himself. If you fail continuously 1 or 2 cases, then your career is over. So that is the point I'm highlighting here. You don't miss out this chance. Moot Court GI completely follow kara. It will help you in your real life competition. Once you go out of the college, now you are enjoying this atmosphere. But once you go out of the college, once you pass out of the college, you will face the real heat of the competition. Competition bharpur. Don't repent. During our college time, we did not pay attention when the Moot Court class was going on. This you will repent when you pass out of the college, when you face the real world. So we have a Moot Court club in our college. We will be conducting Moot Court classes almost every Saturday, except on holidays or if there are any other commitments. So you are all requested to come and join if you feel the importance of Moot Court. And after training you, we will be sending you to participate in Moot Court competitions. They have prize monies as well as certificates. We have sent the 3 teams this year to represent the College of Law in various Moot Court competitions. Students are willing to share their experiences on stage here. Right around. I met Rahul Chibli on stage to share his experience in the Moot Court competition. Thank you very much for listening attentively. Good morning, all of you. The Moot Court competition or Moot Court is the tool to change our professional skill into a great lawyer. When we are talking about who is the courtroom genius, first name brought before us, that is the Nani Palkhiwala. If you want to become a Nani Palkhiwala, if you want to become a courtroom genius, you follow the Moot Court. And without Moot Court, you have no opportunity to go before the dais and practice. If you fail, you have another chance. But in a real court, if you fail, then there is no chance to repeat. You have only opportunity to appeal it. But I thought that if the trial court decides one a case, there is only changed by the Supreme Court. If the lawyer fails at a trial level, it means the trial court lawyer fails. That mistake done by a trial court lawyer is compensated by a party in terms of paying the Supreme Court's lawyer fees. It means you have a responsibility to give to the society, to your client, a valuable legal advice. If your mistake makes their life difficult, their opportunity to develop their lives. And basically, when we are joining the Moot Court club, we have also a knowledge. Myself, my opinion is basically that about the Moot Court club is that the Moot Court club is the milestone for the fourth generation lawyers. Because first generation lawyers have no office of his father or any other thing. But when you are having a fourth generation lawyer, you need to one kind of burden. You have your opportunity to give one pen and hand, and one person is sitting inside you and stating that right so and so, how to make a submission or how to make those applications. Our teachers giving this opportunity from the even first generation lawyers. And even the other for CJ, Justice Elvira Manna is also the first generation lawyer. Then we want to inspire and we want to join the Moot Court club. And my experience personally in the Moot Court competition was really big. Myself, Ravin Chibli, and my colleague Vaishnavi Patel participated in the 22nd National Moot Court competition in Aurangabad. We are qualified for a semi-final round. And 10 teams we are selected. That all 4 teams are from Bangalore, Rest Law College, Symbiosis Law College, and other national colleges or
Jindal universities. Such like teams we will beat. That gives experience about us, what is the language. And when we are seeing their memorials, we build our confidence. But when we are trying to argument, or we give opportunity to argue, then it is clear that yes, we can do it. And we qualify for semi-final round. In the semi-final round, the only 5 teams are in this competition. And that time, semi-final, the regular round makes different. When the judges asking the question, it is very difficult to handle it. They rapidly asking the one point, specific point. But the some contenders is not delivering a proper answer. That makes your mark is dead. But unfortunately, we made that and we missed just final and got the semi-finalists. And this is my experience. So you all join the Moot Court club and you become a Rahul Chibri, you become Ovasmari Khandelwal. Even though our teams are participated in international Moot Court competition and you तुमच्यामधलाच कोणीतरी एखादी नॅशनल मूट कोर्ट असेल किंवा इंटरनॅशनल मूट कोर्ट मध्ये बेस्ट मूटर म्हणून प्राइज जिंकू शकतो किंवा एक बेस्ट टीम म्हणून आपण त्या ठिकाणी फायनल मध्ये जाऊ शकतो आणि फायनल मध्ये जिंकू सुद्धा शकता. इव्हन त्या ठिकाणी जजेस जे आले होते जजेसचं असं म्हणणं होतं त्यांनी आमच्या क्लिप्स पाहिल्या होत्या रिपोर्टरच्या. त्या रिपोर्टरच्या क्लिप मध्ये त्यांनी पाहिल्याच्यानंतर असं सांगितलं की एमपीसी सेवा भाग होता आणि आपल्या गळ्यातला कॉलेजचा त्यांनी असं सांगितलं की यू मस्ट कम टू द कोर्ट, तुमची गरज कोर्टामध्ये आहे. सो त्या हायकोर्टचे जस्टिस जर असं सांगत असतील तर नक्कीच आपल्या मूट कोर्ट क्लबने आपल्याला काही ना काही दिलेलंच आहे. त्यामुळं आपण मूट कोर्ट क्लब जॉईन करावा आणि लवकरात लवकर मूट कोर्टशी धन्यवाद.
I invite Priyanka Deshpande, participated in the Moot Court competition in Pune.
Hello everyone. I started and I guess I will be concluding as well. I think all of you have got an outline of what Moot competitions are and how is it that you have to prepare for the Moot competitions. Me and two of my classmates have participated in Shankara Chauhan 8th National Moot Court competition and I was a researcher in it basically. My experience in this regard is a researcher is a basic researcher. That means when you are given a Moot Court competition case law, it is not just the case law that you have to read, interpret and write your arguments on it. You have to go through all the interpretations that are necessary. You have to look into all the acts, like the Bill Acts. You have to look into all the journals, all. Sometimes when there are no acts which are formulated, for example, our case was in regard to, I think everyone has the Sabrimala case, right? So the case law was in regard to the Sabrimala case only, but in terms of Muslim law. Now you cannot interpret into Muslim law for sure. You have to have an interpretation into their own personal laws. So we went through the entire Quran, basic part, which was necessary to understand what are the fundamental rights or the rights of the Muslim women. Wherein we understood that what we are having into our mind that the Muslim women are denied all their rights. But we like to know that more than any other religion can grant, Muslim women are given the rights of freedom. And this is the truth that you get to know when you read and get into research work of certain things. So I would say when the voters are preparing, the researcher has an equal responsibility on the shoulder of theirs so that they can provide the voters with all the necessary things. Now, moving on towards the Moot Court orientation program, I would say when I was sitting on the first bench, I was not able to see what all the students were doing while sitting behind. I would say that the third year students have already went through all of this procedure, so they won't have equal amount of attention as you all are having, and seriousness as well. Because हमारे moot court के जो journals हैं वो हमने submit कर दिए, तो इसीलिए अब हमें सिर्फ कोर्ट में जाना है और प्रेजेंट करना है. This is what we are having into our mind. But let me tell you, this is not it. Okay. Earlier, we were not having this into our academics. The research part, the moot court part. This was not a part of academics. When you go into the courtrooms, there you used to learn this by observing your. किसी को कुछ बोलना है? अगर आपको आपके views present करने हैं ना, you will also be getting this chance to stand on the stage. Sitting idle over there and talking to someone besides you who is not going to give you any kind of knowledge. और जब free में मिल रही है ना knowledge तो दीजिए, because you have to spare your internet otherwise in YouTube. Okay, so the point is that when you earlier it was not a part of academics, now it is part of academics. Earlier when it was not a part of academics, all the lawyers used to spend almost 5 years of their life learning about the entire procedures. Now you are going to get that equally into your 3-year academic curriculum. So I guess this investment is better than the 5-year investment that you are going to give after you go into the actual world of practicing. I guess that is enough to make you all serious. And second thing is, it might be कि third year में आएंगे तब देखेंगे क्या है. Okay, but start your internships from the first year itself, because by the final year, the amount of certificates that you want, यहाँ पे लिखा है ना कि certificate मिलेंगे, तो हमें तो लगता है certificate का क्या करना है? It is of no use. But let me tell you, everyone says that law is an ocean, and it depends upon which water or drop you drink. And one of its drop is of the practicing into the companies, being an legal counsel of the companies. Okay, in-house counsel of the companies. They won't see your academic results. They want the certificates in your hand. और वहाँ पे जाके आप बोलेंगे अरे हमने तो पार्टिसिपेट नहीं किया, चलो वापस एक बार एडमिशन लेते हैं, नहीं होगा. No one is going to admit that. There you need the certificates in your hand, at least of participation. तो वहाँ पे vocals ये कोई नहीं बताने वाला कि what is the need of moot court competition in your life. Actually, participation is also going to be enough if you are not able to move ahead. But more than that, experience also is what you get into it. Second thing is, हमारे college में, I think you were not there at that time. At that time, we had the former judge of Supreme Court of India, B.S. Shirpurkar sir. What he said into his speech was that when he was practicing, he started practicing, and he used to practice at high court, and he used to greet his seniors when saying good morning sir, good afternoon sir, namaste sir. But what if कोई value नहीं देता? You are wearing the same coat, but no one is giving the value to you inside the courtroom. So वो जो embarrassment feel होती है ना, that you won't be able to handle. So what is it that is going to bring you out of that embarrassment is just this moot court competitions. Whether that be of my college or the legal services authority, they also conduct such kind of competitions, or inter-college, inter-district, university, national or international. When you get into such kind of competitions, you get the knowledge. When you get the knowledge, you try to interpret that knowledge in front of the people who are there. And when you try to share your knowledge is being seen. And that is when you say good morning to someone, they look to your eyes and give back the smile. और barely जाओगे कोर्ट में good morning बोलेंगे कोई नहीं सुनेगा. But when they will understand that yes, उसमें है कोई सवाल, आता है कुछ तो, पेरेंट्स पढ़े हैं, जर्नल्स पढ़े हैं, पढ़ाई की है 3 साल में, तो वहाँ पे जाने के बाद they will respond to your greetings actually. Third thing is, हम जब starting में आए थे कॉलेज में, we were very excited about the moot courts and all. बट सर कोरोना आ गया, 2 साल चले गए. हमारा ओरिएंटेशन, यू आर लकी, you are having in front of you teachers and they are explaining to you. If you are having any queries, we will try to answer them as well. हमें फोन करके पूछना पड़ता था, सर ऐसा हो गया, सर ये क्या करना है, वो करना. They used to give the time as well. This is the most important thing, that the support you are getting from the college. And basically, we spent all our 2 years at home sitting there, reading their acts, some of us. And the thing is, in the entire 2 years, we didn't have any kind of interaction, how it is going on inside the classrooms or even in the college. Everything you are seeing on the screen and you are presenting. You are lucky enough that you are not going to face such kind of challenges into your life. And you are going to present actually into your life how it is inside the courtrooms. This is the most important thing. I wish you all of you are going to take advantage of this particular thing, that you are presenting, you are being present in the college physically and not in the online mode, and are experiencing the Moot Court physically as well. I wish you all the very best. I was not there into your induction program, so I was not able to tell all of this to the students. So I wish you all the very best. I hope to see every one of you participating in different kinds of Moot Court competitions. You can suggest to the teachers as well if you are interested into. And the ones who are very eager to clap their hands, I am very thankful to you all as well. That you are patiently listening. And I guess you are understanding as well. So you understood that this is the last thing that I am saying. Thank you and have a nice day.
मला माहित आहे तुमची परिस्थिती काय. 12 वाजले, भूक लागलेली असेल, सकाळी 7:30 कॉलेजमध्ये हरकत नाही. फक्त मी 5 मिनिट घेतो. थँक्स, लास्ट पार्ट आहे त्याच्यामध्ये. नमस्कार सगळ्यांना. मी मराठीतूनच बोलणार आहे. कारण हर्ट टू हर्ट जर आपल्याला कन्व्हर्सेशन करायचं असेल तर आपली मातृभाषा अतिशय उत्तम आहे त्यासाठी. आणि सरांना पहिल्यांदा मी बाले सरांना धन्यवाद देतो की सरांनी आजचा कार्यक्रम अरेंज केला आणि शेट्टे सरांनी त्याला एकदम छानपैकी आपल्याला समजावून सांगितलं आणि आपल्या इतर पार्टिसिपेंटनी त्याला अजून हे दिलं, त्याला म्हणजे सुशोभित केलं. मला आता एवढ्यासाठीच बोलायचं होतं. मी बऱ्याच वेळा सेकंड इयर आणि फर्स्ट इयरच्या विद्यार्थ्यांना म्हणलं आम्हाला तुमच्या क्लासमध्ये यायचं आहे, पण तो काय योग आला नाही. परंतु आज असा काही छान योग आला की त्याची संधी घ्यावी म्हणून मी तुमच्या समोर उभा आहे. विद्यार्थी मित्रांनो, की मला माहिती आहे की ज्यावेळेस तुम्ही ऍडमिशन घेतलं, एलएलबी ऍडमिशन तुम्ही घेण्याचा प्रयत्न केला किंवा एंट्रन्स एक्झाम देण्याचा प्रयत्न केला, त्यावेळेस तुम्ही कुठेतरी विचार केला असेल की आता मी असं एलएलबी का घेऊ ऍडमिशन. प्रत्येकाचा वेगवेगळा व्ह्यू असू शकतो. परंतु इथं आल्यानंतर ज्यावेळेस तुम्ही अभ्यास करायला लागता त्यावेळेस तुमच्या लक्षात येतं की बऱ्याच काही वेगळ्या गोष्टी आहेत जे की आपण समजल्या होत्या. तर मला हे म्हणायचं की तुम्ही इथं का, किंवा परमेश्वराने तुम्हाला लॉलाच का पाठवलं, हे एवढं असू शकत नाही. त्याच्या पाठीमागे फार काही मोठं कारण असतं की तुम्हाला लॉला का पाठवलं. कारण लॉला परमेश्वराने पाठवायचं कारण आहे की अनेक परमेश्वराने निर्माण केलेले जे ह्युमन आहेत, जे माणसं आहेत, जी परिस्थिती आहे त्याला कसं कंट्रोल करायचं, त्याच्यासाठीच तुम्हाला लॉला, आपल्या सर्वांना लॉला पाठवला आहे. आणि त्याला तुम्ही योग्य न्याय द्याल अशी मी तुम्हाला अपेक्षा करतो. कारण का की समाजामध्ये अनेक गोष्टी आहेत ज्या की तुम्हाला त्या आवडत नाही, ज्या की त्या ह्युमनच्या विरोधात आहेत. आणि त्याच्यासाठी तुम्हाला जर फाईट करायचं असेल तर लॉ सारखा टूल, लॉ सारखं प्रोफेशन दुसरं कुठलं नाहीये असं मला वाटतं. म्हणून सगळ्या गोष्टी असो, मूट कोर्ट असो, तुमचं शिक्षण पहिल्यापासून असो. आता आम्हाला लक्षात नाही आलं सुरुवातीला की इतर डिग्री सारखं आपण पण एक समजा कॉन्टॅक्ट आहे त्याचा अभ्यास केला, विषय संपला, असं नाहीये. तुम्हाला जो काही तुम्ही शिकताय पहिल्यापासून फर्स्ट इयर पासून ते ऍब्सॉर्ब करा आणि स्टोअर करून ठेवा कम्प्लिटली, कारण ते तुम्हाला लाईफ टाईमला उपयोग येणार आहे. आणि ह्याच्यासाठीच मला तुम्हाला सांगायचं होतं की तुम्ही अभ्यास करताना परीक्षा किंवा मार्क्स हा विषय गृहीत न धरता हे नॉलेज मला जीवनामध्ये कंटिन्युअसली वापरायचं आहे ह्या हिशोबाने तुम्ही ऍब्सॉर्ब करा आणि तुमचा अभ्यासाची पद्धत बदलून टाका. अभ्यास करताना तुम्ही डीप मध्ये अभ्यास करा आणि रिसर्चर म्हणून अभ्यास करा, जेणेकरून तुम्हाला वकिली करताना किंवा तुमच्या क्लायंटला तुम्हाला न्याय देताना किंवा समाजाशी तुम्हाला चुकीच्या लोकांशी फाईट करताना त्याचा योग्य वापर होईल आणि तुम्ही सक्सेस व्हाल आणि आपला समाज, आपला देश एक चांगल्या परिस्थितीमध्ये आणाल, चांगली परिस्थिती निर्माण कराल, म्हणजे आनंद निर्माण होईल असा निर्माण कराल अशी मी अपेक्षा करतो आणि माझे दोन शब्द सुनते.
मी कुठेतरी अमिताभ बच्चन यांची इंटरव्ह्यू ऐकली होती. इंटरव्ह्यू मध्ये अमिताभ बच्चनना स्टार्टिंगला विचारलं होतं की तुम्ही ऍज अ बेस्ट ऍक्टर म्हणून तुमचं सगळ्या जगामध्ये नाव आहे, तुमची प्रसिद्धी आहे. त्यावेळेस अमिताभ बच्चन यांनी सांगितलं होतं की ज्यावेळेस मी रेडिओमध्ये फर्स्ट टाइम काम करण्यास सुरुवात केली तर त्यावेळेस तर त्यांनी रेडिओ त्यांना घेतलंच नव्हतं, कारण त्यांचा आवाज किंवा त्याची पर्सनॅलिटी तशी नव्हती. सांगायचं तात्पर्य एकच आहे की कोणीही व्यक्ती एकदम असा अचानकपणे महान बनत नाहीये. कुठल्या किती मोठा पैलवान जर असेल, डाव पेच त्याला कळत नसतील तर छोट्यातल्या छोट्या पैलवानी त्याला होऊ शकतो. तसं तुम्ही लिगल पंडित आहात किंवा लिगल पैलवान होणार आहात भविष्यामध्ये. आपलं हे जे मूट कोर्ट क्लब आहे तुम्हाला माहितच आहे, आपल्या कॉलेजमध्ये मूट कोर्ट क्लब इस्टॅब्लिश केलेला आहे. परंतु गेली 2 वर्ष आता देशपांडेंनी सांगितल्याप्रमाणे तेवढं ऍक्टिव्ह नव्हतं. त्याचे कारण म्हणजे लॉकडाऊन असल्यामुळे जे सर शनिवारी किंवा शुक्रवारी शनिवारी जे काही ते मूट कोर्टच्या संदर्भात जे काही प्रॅक्टिस घ्यायचे, ओरिएंटेशन घ्यायचे, वेगवेगळ्या प्रकारचे प्रॅक्टिसेस आपण मूट कोर्ट क्लबच्या माध्यमातून घेत असतो. उदाहरणार्थ लिगल डिबेट असेल, वेगवेगळ्या प्रकारचे डिबेट असतात. जसं की उदाहरणार्थ फॉर एक्झाम्पल सध्या महाराष्ट्रामध्ये जो काही ज्वलन प्रश्न आहे भोंगा, त्याचा भोंगा असेल किंवा जे मस्जिदीवरती भोंगे असतील किंवा मंदिरावरती भोंगे असतील, त्याच्या संदर्भात वेगवेगळे पक्ष वेगवेगळ्या प्रकारचे स्टेटमेंट वगैरे देत आहेत. हे किती लिगल आहे? मी पॉलिटिकल किंवा राजकीय च्या दृष्टिकोनातून नाही बोलत, परंतु ऍज अ लिगल लॉयर किंवा कायद्याचे स्टुडंट म्हणून किती लिगलाइज आहे किंवा काय करता येईल किंवा त्याचा आधार काय. तर काय कोर्टामध्ये तुम्हाला टोकन बोलता येत नाहीये. हे कन्व्हेन्शनल कोर्ट असतील, क्वासी-ज्युडिशियल ऑथॉरिटी असतील किंवा इव्हन आपलं मूट कोर्ट असेल, मूट कोर्ट मध्येही तुम्हाला बेसलेस बोलता येत नाहीये. तुम्ही जे काय आर्ग्युमेंट करताय किंवा तुम्ही जे काय बोलताय किंवा तुम्ही जे काय सबमिशन करताय त्याला तुम्ही बेस देणं आवश्यक आहे. तर त्याच्यासाठी आपल्याला या मूट कोर्ट क्लबच्या माध्यमातून प्रॅक्टिस घेता येते किंवा आपण त्याच्या संदर्भात उदाहरणार्थ आपल्या कॉलेजमध्ये मूट कोर्ट हॉल आहे. अमिताभ बच्चनने सांगितलं त्यांच्या इंटरव्ह्यू मध्ये की तासन तास किंवा रात्र त्यांनी आरशा समोर उभारून प्रॅक्टिस केली की तेव्हा ते केव्हा नंतर ते अमिताभ बच्चन झाले किंवा तुमचं विराट कोहली म्हणतात ना तासन तास त्या नेट प्रॅक्टिस करायचे आणि त्याच्यानंतर मग ग्रेट बॅट्समन झाले. तसं जर तुम्हाला नाना पालिकवाला आताच त्यांनी सांगितलं नाना पालिकवाला चेवले होता, नाना पालिकवाला सारखे वकील व्हायचं असेल किंवा जे काही याच्यावर शिरवाईस सारखे वकील व्हायचे असेल किंवा आपले जे काही वेगवेगळ्या प्रकारचे फेमस वकील आहेत त्यांनी फार मोठी मेहनत घेतली होती कॉलेज लाईफ पासून किंवा बरेचसे विद्यार्थी मी पाहतो फायनल इयरला मोठं प्रॅक्टिकल असतं. ज्यावेळेस मोठं प्रॅक्टिकल मध्ये तुम्हाला कॉन्स्टिट्युशनल केस, सिव्हिल केस आणि क्रिमिनल केस प्रेझेंट करायचे असते, त्यावेळेस ते प्रेझेंट करण्यासाठी उभे राहतात तेव्हा त्यांचे हातपाय कापतात किंवा त्यांना बोलताच येत नाही, 5 मिनिटे बोलू शकत नाही ते. परंतु असेही विद्यार्थी बघितलेले आहेत की जेव्हा ते स्टार्टिंगला सुरुवातीला भेटतात घाबरतात आणि नंतर एकदा का बोलायला सुरुवात केली बस म्हणजे पर्यंत पुन्हा ते चालूच ठेवतात, कारण अभ्यास फुल केलेला असतो, भरपूर केलेला असतो. मला माहित आहे ज्यांना जायचे कृपया प्लीज जा, ज्यांना भूक लागली मला माहित आहे परंतु प्रत्येक दिवस सारखा असत नाही. काही महत्वाचे दिवस असतात, महत्वाच्या दिवशी काही महत्वाचे प्रोग्राम ऑर्गनाईज केलेले असतात. थोडीशी कळ आपण सोसू शकतो. मी म्हणतो ना 5-10 मिनिट, जास्त काही वेळ नाही घेत. तर मुटकोटची पार्श्वभूमी तुम्हाला मी समजावून सांगतोय. मुटकोट क्लब मध्ये किंवा हे जे काय आहे डिबेट असतात किंवा मुटकोटचे काही वेगवेगळ्या प्रकारचे जे काही इन्व्हिटेशन असतात वेगवेगळ्या कॉलेजमधून येणारे, त्या माध्यमातून आपण त्या मुटकोट कॉम्पिटिशनची तयारी वगैरे करत असतो. तर बघा, कुणाला जमलं, कुणाची इच्छा असेल. काही विद्यार्थी अनफॉर्च्युनेट आहेत. आता तुम्ही म्हणल्यासारखं दुर्मिळ ते स्वतःला समजतात, खरंच आहे ते. कारण कॉलेजचे 3 वर्ष निघून गेले, परंतु शेवटच्या वेळेस किंवा शेवटच्या वर्षीच त्यांना ऑपॉर्च्युनिटी मिळाली की मुटकोट मध्ये कॉम्पिटिशन मध्ये किंवा जी काय प्रॅक्टिस वगैरे आहे किंवा मुटकोट हॉल त्याचा वापर करणे किंवा त्याचं युटिलाइज करणे, त्यांना ते जमलं नाही. तुम्ही नशिबवान आहात कदाचित, कारण भविष्यामध्ये लॉकडाऊन पडणार नाही. कारण सगळ्यांनी डोस घेतलेला आहे, मुलाचा डोस घेतलेला आहे. त्याच्यामुळे बहुतेक ते काही परिस्थिती येणार नाही असं गृहीत धरता किंवा ईश्वराकडे प्रार्थना करून काय हरकत नाही. तर कोणाला इच्छा असेल तर लवकरच गुगल फॉर्मच्या माध्यमातून त्याचं रजिस्ट्रेशन आपण चालू करणार आहोत. फक्त प्रॅक्टिस करा, जास्त आपण कॅन्डिडेट घेतच नाहीये. अपेक्षा एवढी आहे की एवढ्या 50 किंवा 1000-2000 विद्यार्थ्यांमधून एखाद दुसरा जरी नाही पार्टीवाला झाला तर आपल्या कॉलेजचं नाव उज्ज्वल होईल. तर कार्यक्रम घेण्यासाठी ऑथॉरिटीने आपल्याला परमिशन दिली. मी ऑथॉरिटीचे प्राचार्यांचे आभारी आहे. आमच्या ह्या कार्यक्रमामध्ये ऍज अ रिसोर्स पर्सन म्हणून मुटकोट ओरिएंटेशन देण्यासाठी ऍडव्होकेट शेट्टी सरांनी मेहनत घेतली, ते घेतात. ऍक्च्युली कोऑर्डिनेटर जरी असेल तर जास्त काम शेट्टी सरच करत असतात, कारण बाकीच्या इतर जे काही रिसर्च सेंटर असेल किंवा नॅक असेल किंवा इतर जी काही गोष्टी असतात कॉलेजच्या त्याच्यामध्ये आम्ही बिझी असतो, परंतु जास्त करून काही ते आपले शेट्टी सरच देतात. त्याच्यामुळे मी पर्सनली माझ्या वतीने मी शेट्टी सरांचे फार आभारी आहे. ते विद्यार्थ्यांसाठी वेळ देतात. जे काही मुटकोट कॉम्पिटिशन मध्ये विद्यार्थी भाग घेतात, जास्त करून सरच जास्त वेळ देतात. म्हणजे वेळ देऊ शकत नाही, मी त्याचा केस करतो. आणि त्याच्यानंतर लास्ट बट नॉट लिस्ट, तुम्ही सर्व विद्यार्थ्यांनी आज इतका वेळ आमच्यासाठी दिला आणि आपल्या सर्वांचे महत्व आभारी आहे.
काय चाललंय सर?